Hey there, everyone.
Welcome back to our channel. Today we are going to see the differences between the lease agreement and leave and license agreement.
Lease. A lease is a legally binding agreement between a landlord and a tenant that confers the right to possess and use a property for a specific duration. This agreement outlines various terms and conditions, such as the amount of rent, the lease term, and the responsibilities of both parties. It is defined in Section 105 of the Transfer of Property Act, 1882. A lease of immovable property is a transfer of a right to enjoy such property, made for a certain time, express or implied, or in perpetuity, in consideration of a price paid or promised, or of money, a share of crops, service or any other thing of value, to be rendered periodically or on specified occasions to the transferor by the transferee, who accepts the transfer on such terms.
License, on the other hand, a license is a permission or authorization granted by the licensor to the licensee to use the licensor's property for a specific purpose, without granting exclusive possession. A license does not establish a landlord-tenant relationship nor confer the right to exclusive possession.
License is defined under Section 52 of Indian Easement Act, 1882. Where one person grants to another, or to a definite number of other persons, a right to do, or continue to do, in or upon the immovable property of the grantor, something which would, in the absence of such right, be unlawful and such right does not amount to an easement or an interest in the property, the right is called a license.
Key distinctions between a lease and a license include:
1. Possession. A lease provides the tenant with exclusive possession and control over the property, enabling them to use and occupy it. Conversely, a license does not grant exclusive possession, allowing the licensor to limit or deny access to the property. 2. Duration. Leases typically have defined terms, specifying the period for which the tenant is entitled to possess and use the property. Licenses, on the other hand, are generally for shorter periods and may be revocable or non-renewable. 3. Transferability. Leases are often transferable or assignable, subject to the landlord's consent. In contrast, licenses are generally personal to the licensee and cannot be transferred or sub-licensed without the permission of the licensor. 4. Legal protection. Leases are frequently governed by specific laws and regulations, such as rent control acts, which safeguard the rights of both the landlord and tenant. License agreements, however, may not benefit from the same degree of statutory protection and are primarily governed by contract law principles. Note: it is crucial to meticulously review and comprehend the terms and conditions of any lease or license agreement before entering into them, and, if necessary, seek legal counsel to ensure a proper understanding of rights and obligations.
Laws. The laws that govern leases and licenses may vary depending on the jurisdiction. However, in India, the following laws are generally applicable to leases and licenses. Leases.
1. Transfer of Property Act, 1882. This law governs the transfer of ownership rights in immovable property, including leases. It provides rules regarding the creation, duration, renewal, and termination of leases. 2. Rent Control Acts. Different states in India have their own rent control acts that regulate the relationship between landlords and tenants, particularly concerning rent control, eviction procedures, and tenant protection. 3. Indian Contract Act, 1872. This act governs the general principles of contract law, including the formation, terms, and enforcement of lease agreements.
It applies to leases as lease agreements are contractual in nature. Licenses.
1. Indian Easements Act, 1882. This law deals with the creation and regulation of easements and licenses.
It defines the scope of licenses, their nature, and conditions.
2. Specific state laws. Certain states, such as Maharashtra, have specific laws that govern licenses for immovable property. For example, in Maharashtra, licenses for the use of premises are regulated by the Maharashtra Rent Control Act, 1999. Additionally, it is important to note that some specific types of licenses, such as intellectual property licenses or licenses to operate certain businesses, may be subject to specific laws and regulations specific to those areas. Case laws. 1. CM VPN Ramchandra Rao, Air 2004 SC 2103, it was held that the difference between a lease and a license is to be determined by finding out the real intention of the parties as decipherable from a complete reading of the document, if any, executed between the parties and the surrounding circumstances. 2. Associated Hotels of India Limited v. RN Kapoor Air 1959 SC 1262. This case is considered a landmark judgment in relation to the distinction between leases and licenses. The Supreme Court held that the substance of the agreement would determine whether it is a lease or a license, rather than the nomenclature used by the parties.
So let's summarize the differences between the lease and leave and license.
1. As opposed to a lease deed that transfers an interest in immovable property, a leave and license agreement merely allows the licensee to occupy the licensed premises. 2. A lease for a period of 1 year or more is mandatorily required to be registered, whereas since licenses are usually for a fixed term up to 11 months, they do not require registration, but it's better to go for registration.
3. The license is more licensor-friendly as it does not entail specific obligations as mandated under various rent control laws.
4. Unlike a lease, in a license, the licensor does not give exclusive possession to the licensee and can enter upon the property and use it without the consent of the licensee. Prior notice generally should be given.
5. Unlike a lease, a license ceases to exist if the property is sold during the tenure of the license.
6. Lease does not come to an end either by death of the grantor or the grantee, but license does end with the death of the grantor or the grantee. 7. Lease entitles to any improvement or accession made to the property, but license does not. 8. Lease is both transferable and heritable, but license is neither both transferable and heritable.
Hope you got some clarification between the two agreements.
Don't forget to hit that like button and subscribe for more law family friendly tips and fun. Take care.
Thank you.